Now, cognizant as I am of what Gillian has just said, I don't think it is really very possible for me to give you a total overview of the Companies Bill in 30 minutes. Gillian has mentioned an ability on my part to pick out the salient features of something. Perhaps I do have that ability, but certainly I know people, particularly in this audience, who are better at the intricate detail than I am, and I see my co-author Jared here. Jared is a very good detailed person. So we can do the overview, and if there are specific questions, please feel free to interrupt or to ask later. So the first thing I just want to talk about is the fact that this Companies Bill has been a long time coming. And as Gillian has mentioned earlier, its genesis was really in the report of the McDowell Report on Company Law Compliance in 1998, where it called for a single comprehensible code. And from there, as you know, that was really about corporate enforcement. And so the first thing that happened was the enactment of the Company Law Enforcement Act in 2001. And that established on a statutory basis the Company Law Review Group under Section 67. And from there, the ball started to roll in relation to creating the template for this single comprehensible code. And the first report of the Company Law Review Group was really the template for this bill that has now gone through various stages of enactment. Now, there are firstly, I want to say there is a paper in your pack, and also I've taken bits out of the Companies Bill for you in relation to sections that to which I'll be referring. And so at the time that I was putting that together, this bill had passed all of the Dáil stages, and now the latest is that it has been through the Seanad committee stage, or the first stage in the Seanad, as of the 17th of June. And so there are some amendments, and the amendments are now up on the Oireachtas website, and Mary and I both had a bit of a moment this morning when we were looking quickly through these to see if there were some significant changes, and Mary's going to talk about one that is a significant section change in her area dealing with lending. But there's not much, as far as I could see very quickly, in the areas that I am going to cover. Another point then is this discussion as to when this is really going to happen. I am working now with Tom Courtney, where, as Bloomsbury author, is going to be publishing a book on the new Companies Act. I'll be looking at the insolvency bits. Tom's view is that this will be enacted in November, but I think now at this point we might just start a bookies run on it, because there's quite a bit of disagreement as to when this will be, and so we don't want to be previous either about talking too much about something, but nevertheless we're looking at a piece of legislation that is more or less in its final form. Now, one other thing, that is that Mary and I decided that today we would be descriptive. In other words, that I'm not going to indulge in any academic criticisms of the bill at all, really. But so in other words, I hope that it will be useful to you in the sense that it is descriptive. So last thing, just on this slide, the legislation is a single code. How long it will last in my lifetime as being a single code is, you know, there's always going to be something else that has to be enacted. And then the question about whether it's comprehensible is something that you will be having to think about yourselves. So, just to start with, this is about the structure of the legislation. So the legislation in its entirety, and again some of you will be well aware of this, others may not, and be just thinking, can I just know something about this bill before it's too late? The legislation is driven by this phrase, think small first, which is actually borrowed from the UK Company Law Reform Project, which took place before the UK 2006 Companies Act was passed. The focus is on the private company limited by shares, and everything else is regulated by reference to the private company limited by shares. So the structure of the Act is that it is in 2 volumes. Parts 1 to 15 deal with the private company limited by shares. So parts 1 to 14 deal with that company. Part 15 is about the functions of the company registrar. In volume 2 you have parts 16 to 25, and those parts start to deal with other kinds of companies. So part 16 deals with this new animal called the DAC, the Designated Activity Company. Part 17 deals with PLCs. Part 18 deals with companies limited by guarantee, private companies limited by guarantee. So in relation to the DACs, for example, the way this is done is that it's regulated by parts 1 to 14 and part 16, to the extent that part 16 modifies or disapplies the first parts 1 to 14. And then we have a range of schedules, and Schedule 1 and Schedule 7 are the ones that are most important because they deal with the constitution of the private company limited by shares and the DAC, the Designated Activity Company. Okay, so the focus is to make things simple. Think small first. The private company limited by shares, because this is the vehicle through which small and medium enterprises operate. And so it is expected that the private company limited by shares will be the vehicle of choice for most companies. Okay. So then, this section 9 is just a very interesting section in that it describes and enacts what I have just been talking about. So that it says that subject to subsection 3 and 4, all of the law in this Act in relation to private companies limited by shares is to be found in parts 1 to 14 and schedules 1 to 6. And the law in relation to other types of companies is to be found amongst the provisions of parts 16 to 25 and parts 1 to 14, as applied or adapted by parts 16 to 25. There are a number of different companies listed in parts 16 to 25. The main options for people involved in the small and medium enterprise sector would be the Designated Activity Company or the company limited by guarantee. PLCs are also dealt with. But I just wanted to mention in passing, and it's mentioned in the paper, 2 companies, types of companies, which might be of interest to people with niche practices in the audience. The first are external companies. And external companies are regulated in part 21 of the legislation. And these companies are companies which are branches of foreign companies. And so in the legislation now, there is a distinction made between a branch of a foreign company and a place of business of a foreign company. And the distinction between branch and place of business determines the registration obligations of anyone dealing with a part or related aspect business company of an external company. So that's part 21. I thought that might be worth mentioning for some people. And then also investment companies are regulated in part 24. And these are PLCs. Again, this is a niche practice, but I'm sure there are some of you involved in this industry. These are PLCs established for the collective investment of funds in property. So in other words, any collective investment funds are regulated in part 24. Okay. So the big question then is to what extent are things changing here, or to what extent is it simply consolidation? And so I want to just attribute and mention the Arthur Cox microsite, which is open to public registration, and there is a very sort of good guidance around the legislation which you will find useful. And so, in summary, the innovations that are described in relation to the legislation are as follows. Firstly, the introduction of a summary approval procedure in Part 4, Chapter 7. Now, this procedure is the sort of special resolution, declaration of solvency type of procedure, which has now been standardised for some things that companies want to do. The one that people want to do mostly and forget that they really need to be very careful about it is the provision of financial assistance for the acquisition of a company's shares. We know some people who forgot all about this very recently, but there have been other people who've forgotten all about it as well. One of them was Chris Comerford, you might remember him, and that Section 60 breach was revealed by the fact that he tried to sue in relation to the transaction. So the point is, this summary approval procedure is now an innovative standard approval procedure for those kinds of things: financial acquisition, reduction of capital, and so forth. The second innovation that's a big picture item is this codification of directors' duties, which people have mentioned and are talking about. And that is in Part 5, Chapter 2, and in particular Section 228. A third innovation is the standardised categorization of corporate offences. Again, probably a minority interest because we don't have much of that really. The fourth innovation, it's a change, is in relation to capacity. That's ultra vires and objects clauses, and the authority of agents. The fifth innovation is in relation to governance. Many of the provisions of what have been articles of association are now statutory provisions. There are statutory provisions now in relation to the operation of meetings and some issues in relation to resolutions. And then finally there are the transitional obligations dealing with this transition period. So today I'm going to talk about the capacity and authority of agents issue, and governance, and transitional obligations. Now, I picked those because the capacity thing, the ultra vires and its reform, was something that was driving some part of this legislation forever, and now it's happened. And I know it's not that significant in practice, but it is driving the creation of the designated activity company, which people are very worried about as to what that is. The governance issues are important because it changes the way the articles of association will look. Basically, these are now going to be called the constitution of the company. And then the transitional obligations are things you need to start thinking about sooner rather than later, depending on when the legislation is enacted. Okay. And just to interrupt Gillian, I didn't bring my clock up, so if you want to shout at me whenever, that's fine. Okay, so those are the things that we're going to look at today, and Mary will be looking at the summary approval procedure anyway, so you'll get a lot covered. Okay, so this is the DAC, not the animal in the Himalayas, but this is something that people are very worried about. Like, what is this? So we're going back to the structure of the Act. Firstly, the private company limited by shares is predicted to be the most important company. Now, I'm not entirely sure that that's going to be right, but you know, again, as I said, I'm not wandering into academic considerations at the moment. The designated activity company is the alternative to a private company limited by shares. But what's driving the alternative is quite simply this issue about objects. So the private company limited by shares will have unlimited capacity under Section 38 of the bill, meaning that it will have no objects clauses and no specified business activities. If you want to have a private company limited by shares that has specified business activities, the DAC is your animal. That is why you need a designated activity company. Okay? So as I have illustrated about the structure of the legislation, the DAC is regulated by parts 1 to 14 that apply to a DAC, except to the extent that they are disapplied or modified by this section, Section 966, or any other provisions of this part, Part 16. All right, so that's your next best option. If you don't want to have no business objects at all, the DAC is what you're going to do. So the difference, the main difference between a limited, an LTD, and a DAC is this, that there will be an set of business objects specified in the constitution of the DAC. Okay. Now, I'm going to come back to that in a moment and why during the transitional period what people will do about DACs or not. But just to say that in the transitional period it is expected that there will be some migration back and forth between these two kinds of companies until people decide which is their preference. And that is possible during the transitional period. But then after the transitional period, it is possible for any kind of company to re-register as any other kind of company. So if you're a limited and you don't like the unlimited business diversification, you can change to a DAC or vice versa, or you can change to a company limited by guarantee. And in my paper I have provided you with the relevant sections in relation to re-registration as different kinds of companies as time goes on. Okay? And then I'm going to look at the transitional issues later on in the presentation. Okay, so a DAC is required in this very obvious situation where the company itself decides it wants to have specified business activities. In other words, that for whatever reason it's considered not to be wise to have an unlimited business activity or choice. And also the DAC must be formed where the members request that a DAC is formed. So the provision is that if 25% of the members request that the company has specified activities, then a DAC has to be formed. Okay? So as I said, the difference between limited and DACs is totally driven by this sort of not really very innovative idea of abolishing objects clauses and ultra vires, but it is sort of a compromise position that perhaps some companies might want to specify their business activities. And then you'll see in the other bullet points that there were some add-on requirements as to when DACs would be required. So where a company wants to list debt securities on the stock exchange, then a DAC has to be formed. Okay? And there are quite a lot of companies on the stock exchange that list debt securities on the Irish Stock Exchange. So that was a very interesting little journey I took to see what that was all about. And so this is billions that we're talking about in terms of debt securities listed on the stock exchange. But it's not everybody's bread and butter, so it doesn't really arise in most people's situation. Thirdly, there is a requirement in the legislation that where a company is operating as a credit institution or insurance undertaking, it must have specified activities and it must be registered as a DAC. Okay? A DAC a designated activity company may be a private company limited by shares or a private company limited by guarantee. And the only difference is that between that and a limited or a CLG is that there are activities specified. Now, in the transitional period, when there are options available to people converting companies, all DACs that are converted initially will be private companies limited by shares, and I'll come to that later. Okay, right, so capacity is the thing, one of the things I said I'd talk about. So, to the joy of all law students and myself, there will now be no more ultra vires. I have been saying it's going to be abolished for 20 years, and here we are. So, if you set up a private company limited by shares, it, under Section 38, will have full and unlimited capacity to do whatever it wants to do. Under Section 975, a DAC shall have the capacity to do any act or thing stated in the objects set out in its memorandum. Okay? So in a DAC, the objects still have a role in terms of constraining the activities of the company. And similarly, for PLCs, Section 1014 says that a PLC will have an objects clause, and that will have the capacity to do any act or thing stated in its objects set out in its memorandum. And I've given this quote from the Reno Weekly Gazette because there will be former students here who know that I've been quoting Leonard Seeley for 20 years, that ultra vires is a sledgehammer used to crack the nut of specifying your business activities. And it turns out it was an American phrase all along. I didn't know that. So what does this mean? Well, what it means is if you want to specify your business activities, the objects clause in a DAC or a PLC is now a rule of internal discipline only. There's no ultra vires, no voiding of the transaction because it's outside the objects clause. Now this was done in English law since 1985, and by the way, any English cases on ultra vires should always be read in that context. And so it's a rule of internal discipline, and so the Section 976 sets this out for a DAC. So it provides that the validity of an act done by a DAC shall not be called into question on the ground of lack of capacity by reason of anything contained in the DAC's objects. So ultra vires doesn't arise. But under Section 976, subsection 2, a member can bring proceedings restraining the doing of an act beyond the DAC's capacity. So in other words, there can be injunctive relief in relation to wandering off doing something else that wasn't agreed. Also, Section 976, subsection 4, addresses the question of directors being liable for losses caused to the company if they do something that is outside the objects clause. Right? And then the section also allows for a special resolution to absolve the directors from any liability for wandering outside the objects clause. Okay? So it's a rule of internal discipline only. Now, the sort of academic discussion is, do we really like this free-for-all business diversification that the limited is going to have? Or do we actually want to specify some activities, and how do we deal with it? And we have now this good rule of internal discipline, which is much better than ultra vires. And my own view, just a little bit of academic thing, is I'm not really sure that we want companies, if we were members or creditors, to be able to do any damn thing they want. But that's a matter that we'll see. We'll see which are the preferred vehicles for particular companies. Okay. Now, as all my law students will know, that an issue that goes hand in hand with ultra vires, all gone now, is this issue about authority of agents. And that is still a bit difficult. And in my view, it's still difficult under this Section 40, which is designed to address this. Now, Section 40 is a combination of, as I've said in the paper, original law and a sort of a revamping of the European Communities regulation. So it basically provides that the board of directors will have full authority to bind the company in any transaction, and that anyone else who is given the authority to bind the company must be registered. Okay? So it provides that the board of directors of the company and any registered persons shall be deemed to have authority to exercise any power of the company and to authorise others to do so. Any person who is authorised by the board to bind the company must be registered. So that's that. But what that means is that if somebody has limited authority, which is often the case, where they have, say, authority to borrow up to 100,000, those people with limited authority cannot be registered. So it means that a third party dealing with the company may be caught by a lack of authority on the part of Joe, who says he's perfectly in a position to act for the company. Or similarly, the company will be caught by somebody acting outside their authority. And so the last sections of Section 40 try to deal with that. And they deal with our old problems of ostensible, apparent and actual authority. And so the sections say that where Section 40, subsection 9, says that where there is a question of ostensible authority, no reference shall be made to the company's constitution. In other words, the idea is that you cannot, as a company, talk about the constitution and rely on that to get out of a transaction. That's the idea. Section 4011, however, says that these rules are in addition to and not in substitution for the rule in Torcon's case, which is the indoor management rule. In other words, that outsiders are not bound by the internal limitations in a company. But the problem is that in many of the actual cases on the authority of agents, the ostensible authority from a third party's point of view is built up by reference to the Constitution. And so these two sections, in my opinion, are contradictory, and that they represent two different lines of legal argument. And so that is going to have to be resolved. As I said, I'm not getting involved in the academic sort of criticisms, and I may have missed something, but this is what it looks like at the moment. The Section 40, subsection 9, provides a limitation on existing case law that perhaps might not have been really thought through. I'm just going to, and I have in the paper referred to Ulster Factors Limited versus Enton Glen Limited. It's just a nice Irish case which illustrates the facts of these kinds of cases. The ultra vires problem is dealt with, and then the authority of the agent problem is dealt with. Okay, so Gillian's saying 5 minutes. So the last, governance. Governance is now codified quite a bit. This is very interesting, but I want to talk about the transitional obligations, so I'll just fly through this. Part 4, Chapter 4, deals with the minutes, the proceedings of the board meetings and so forth. Everything can be changed here except sections 166 and 167. 166 refer to the minutes of the proceedings of the directors, and section 167 concerns audit committees. Really interesting thing, though, is that a lot of this is articles of association in statutory form. And so a really important question for you is to what extent they can be contracted out of or not. And the answer is that in this part, as I've said, most of it can be changed except for sections 166 and 167. Okay. So I've said here, if you can see 158 are basically provides a statutory format for Article 80 and the Managing Director, Article 101, but it could have changed since then. the 101 article. And then Part 4, Chapter 6 deals with meetings of shareholders. Some very important things, which again as an academic I'd like to be talking about, but I won't today. The important thing is that for private companies limited by shares, AGMs can be dispensed with under the terms of Section 175, as long as the unanimous written procedure is followed under Section 193. Section 176 allows for participation through technological means and imposes a duty on the company to provide that. And Section 194 reenacts that circular resolution provision, so that circular written resolutions can be made instead of having a meeting where an ordinary resolution or special resolution is passed. And note that Section 194 gives this enabling ability to companies, notwithstanding anything to the contrary. So 2 big governance changes. The AGM can be dispensed with. Well, the second one isn't a big change, but it's really sort of entrenched now that a circular resolution can be used. As I say to my students, nothing beats a meeting of people in a room if they want to start objecting to something, and this, in my view, weakens governance, but it is business friendly in some ways. Right, quickly, help the transition period. What do I do? What happens? My view, just going on what Tom Courtney has said, is that this will be passed in November. The transition period, as you'll see in my handout, will last for 18 months following that date. And so decisions have to be made in terms of the provisions of the Act by February 2016. Because you have to have the options made 3 months before the end of the transition period. So if we think of November, February 2016. So here are the options for existing companies. Register as a limited, a private company limited by shares using adapted existing memos and arts, which will now be a constitution. Register as a limited, a private company limited by shares with a new constitution under Section 59(1). Or you can re-register as a DAC, a designated activity company, where a resolution is passed where the members want it under Section 56(1). Or re-register as a DAC, this is all in the handout, a designated activity company where you're required to do so because you're listing debt securities or because you're a credit institution. Or re-register as a DAC where the court orders that you should be registered as a DAC. In the 3 cases where existing companies re-register as DACs, they will be registered as DACs limited by shares. Okay? Now, those are the tricky options available. In the meantime, sorry, yeah.
Just one very quick question. Am I right in thinking that every single company in the country will have to re-register?
Yeah, so that's good news.
I'm actually curious in accounting, not as a...
Yeah. Oh yeah, sorry, it was good news for Laura. A little bit of farming has to be done.
Every single small, tiny...
Yeah. Okay. Yeah, so in the meantime, before this transitional period ends, Section 5 is important because there's a real transition period saving provisions, Section 5. You know, when you don't get round to doing stuff, it just provides a continuity for existing companies, so that the repeal of previous enactments will not affect the incorporation of companies registered. So everything is going to be repealed, but the companies will still be okay for the moment. And then it goes on to state that documents which refer to any former enactments shall be referring to the corresponding enactment of this Act. And then importantly, I just picked out that subsection about funds for people who might be concerned about accounts and funds. Okay, so that's the transition period. Now I had more detail in relation to the registration processes as limited. and so forth. But I don't think I have time to do that for you. But I just want to say this, that there are this is all described in the handout, there's some little lacuna and sort of different things going on. So in relation just to the first type of company, re-registering using your existing memo and arts, taking out the objects clause and sticking in the rest of it, but a lot of the articles will be now in the legislation, doesn't seem to have a consent procedure as such, which is interesting, but just perhaps a hole in the thing. And the other thing that I wanted to say is that there is a default point, and it's mentioned in the paper, and that is if you actually do nothing, by the end of the transition period, all companies will be deemed to be a private company limited by shares with unlimited opt-ins. Is that all right? Yes. So the last thing is just to say there's lots to be done. And future seminars, possibilities. Mary and I were talking about this codification of directors' duties, categorization of offences, or something else that may be of interest to you. We're happy to do, but we'll wait and see when it's enacted. Okay? Thanks, Jimmy.
Thanks very much, Mary.